Before we get started, Mr. Bonaventura, do you prefer Bonaventura Flores or Bonaventura Flores?
Bonaventura.
Say that one more time.
Bonaventura Flores.
Both together.
But you know how you pronounce it. How would you prefer to be called? Both names.
Just Bonaventura would be perfect.
Okay, I'm happy with either one. I may not pronounce it as well as you, but I just wasn't sure if you wanted the hyphenated as we make the record or just Bonaventura.
Bonaventura would be fine.
Bonaventura.
Yeah.
Got it. Okay. Well, let's get on the record then, please, in what is position 8 on our trial calendar. It is Tuesday, December 14th, and we have jurors assembling downstairs in courtroom 1D for the trial of case 18 SC 162212, State versus Bonaventura. Mr. Bonaventura is here with his lawyer, Mr. Franklin, and a colleague, Mr.
Singleton.
Mr. Singleton. Welcome, Mr. Singleton. The state is represented by Mr. Rao. And it is my understanding through Ms. Nelson that contrary to what we heard on Friday, Mr. Bonaventura is now inclined to enter a plea. Is that correct, Mr. Franklin?
That's correct, Your Honor.
And this plea will resolve not only the 18 SC case, but as well, Mr. Bonaventura had an open, unindicted matter that arose out of alleged conduct in jail. So it's more recent than the 18 SC. And I believe there's an accusation that Mr. Rao has drawn up that Mr. Bonaventura will be pleading to today as well.
Yes, sir.
Okay. Mr. Bonaventura, if that is indeed your wish to move forward with a plea, then what's going to happen in a moment is that Mr. Rao is going to put you under oath. He'll ask you to raise your right hand. You'll be sworn in, and then you'll be asked a bunch of questions. None of them should be surprises. It's covering things you and Mr. Franklin have already discussed, I suspect, many times. But you'll need to answer those questions truthfully and completely. It's real important that if you have any questions, because what someone said didn't make sense, or because the acoustics are bad, you couldn't hear it, or whatever reason, you let Mr. Franklin or Mr. Singleton or me know, wait a minute, I don't understand what we're doing here, and we'll stop and make sure that you do understand what it is we're talking about. Will you let me or one of your lawyers know if you've got a question?
Yes, sir.
Great. The other thing I'm going to ask you to do is that when you are speaking, if you'd lean in towards the microphone, you are soft-spoken, which is fine, but it's important that the court reporter be able to hear what you've got to say. And you'll be answering lots of questions. It may be yes or no to a lot of those, but she still needs to hear yes or no, whatever your answer is. Okay, so belt it out close to the microphone.
Okay.
Great. Mr. Rao, when you are ready, please.
Yes, Judge. And for the court's edification, defendant will be pleading guilty to both indictment numbers and accusation numbers. For 18 SC 162212, the defendant will be pleading to an amended charge of voluntary manslaughter on count 1. State's recommendation will be 20 years to serve. Count 2 would vacate by operation of law. Count 3, aggravated assault, would merge into count 1. Count 4, possession of a firearm during the commission of a felony. The recommendation is 5 years to serve to run consecutive to count 1. Counts 5 and 6, because they are attempt charges, the maximum charge for influencing a witness is 5 years. Because it's an attempt charge, the maximum is 2.5. That's the state's recommendation on both counts 5 and 6 to run consecutive to each other and consecutive to count 4. And therefore the net total on 18 SC 162212 would be 30 years to serve. On 21 SC 179973, count 1, possession of a dangerous weapon or drugs by inmate, the state's recommendation is 5 years to serve. Count 2, criminal damage to property, the state's recommendation is 5 years to serve. Counts 1 and 2 to run consecutive to each other, and The entirety of that accusation would run consecutive to the indictment 18 SC 162212, again, for a total net sentence of 40 years to serve.
Got it.
Mr. Bonaventura Flores, or Mr. Bonaventura, can you raise your right hand? You swear or affirm that the statements that you provide the court today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can lower your right hand. Please tell me your true, correct, and legal name.
You can put your hand down now.
Okay.
What is your true, correct, and legal name?
Darian Bonaventura Flores.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
How old are you and how far have you gone in school?
23.
How far did you in school?
High school.
Did you finish high school?
11th grade.
Are you able to read, write, and understand the English language?
Yes, sir.
Okay. Do you understand that you were originally charged with the following offenses on 18 SC 162212? Count 1, murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, possession of a firearm during the commission of a felony. And counts 5 and 6, criminal attempt to influence a witness. And that in exchange for your plea of guilty, the state's recommendation will be as previously indicated to the court. Do you understand, sir?
Yes, sir.
Have you reviewed these charges with your attorney? And have they advised you about the potential minimum and maximum sentence to each charge that you're pleading guilty to, as well as the charges that were originally before you?
Yes, sir.
You understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses that you might have?
Yes, sir.
Do you need more time to discuss this case with your attorney?
No, sir.
Are you satisfied with the services?
Yes, sir.
And counsel, do you waive formal reading of both indictment numbers?
So waived.
And do you waive any and all defects therein?
Yes, specifically as to his first name, the indictment's accusation reflects the first name of Derry, D-E-R-I. His first name is Darian, D-E-R-I-A-N, and we waive that defect and any others for purposes of this plea.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of a total net sentence of 40 years to serve, the breakdown as previously indicated to the court? Do you understand that, Mr. Bonaventura?
Yes, sir.
Do you understand the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, sir.
Do you understand that if you're currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes, sir.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand if you're not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 5 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses by entering a plea of guilty today?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand, sir?
Yes, sir.
Has anyone forced, threatened, or promised you anything for you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Will you repeat that, sir?
Is it your decision to waive these rights that I previously indicated and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges and indictment numbers 18 SC 162212 and accusation number 21 SC 179973? Guilty or not guilty?
Guilty.
Are these guilty pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have only 4 years from today for a felony charge, and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
Judge, as it relates to indictment number 18 SC 162212, should this case have gone to trial, the state would expect the evidence to show and prove beyond a reasonable doubt that on June 14th, 2017, the defendant was responsible for the death of Elijah Smith, a 16-year-old kid that was sitting in the front passenger seat of the defendant's girlfriend's vehicle while they were at 3190 Old Milton Parkway in Alpharetta, Georgia, within the jurisdiction of Fulton County at a Quick Trip. The events that preceded that and then thereafter took place after the incident are as follows. On the night of June 13th, 2017, the co-defendant in this case, Callie Carlin, the defendant's girlfriend, received a Facebook message from an individual by the name of Shane Holder asking her if she wanted to purchase marijuana. She agreed and she did so on behalf of the defendant. They both traveled from her residence at 1038 Sasha Lane in Roswell, Georgia, to the extended stay located right across from the Quick Trip where the death of Elijah Smith took place. They traveled there. They went to room 309 at the extended stay where Shane Holder was at, purchased marijuana, and also inside the room was Elijah Smith. Mr. Smith approached both the defendant and Hallie Carlin, indicated if they wanted to match, which was essentially to, I guess, share the same blunt and smoke marijuana, but they both all realized that they didn't have the materials to actually smoke marijuana. So they traveled to the Quick Trip, which was right across the street. Video surveillance shows Ms. Carlin, as well as the defendant, coming to the extended stay at approximately 12:03 a.m. And at approximately 12:13 a.m., you see the defendant, Ms. Carlin, as well as the victim go out the front door, and a witness, Shane Holder, observed the three of them get into Ms. Carlin's vehicle. And she was operating her mother's vehicle at the time. It was a 2015 Honda CRV, which will become relevant as I provide the factual basis. At approximately 5 minutes thereafter leaving, Ms. Carlin's Honda CRV is seen entering the Quick Trip parking lot. You cannot necessarily see what is going on inside the vehicle. If you adjust the, I guess, lighting on the video surveillance program, you can make out an individual in the front seat and potentially an individual in the back seat. But the only person that gets out of the vehicle is Ms. Carlin. She makes a purchase at the Quick Trip and about approximately 5 minutes thereafter enters the vehicle, at which time she indicates that she provided the cigarillos to Mr. Smith. He responded, "Thank you." And then she heard a boom that was akin to a tire pop or firecracker. At least that's what she thought at the time. She looked over to Mr. Smith. Mr. Smith appeared to be in shock, at which point in time he leaned over to her. And at that point, she realized that he had a defect in the back of his head that was consistent with a gunshot wound. She looked over to the Mr. Bonaventura, the defendant, who indicated and spontaneously uttered they were about to be robbed. Miss Carlin asked him, well, where's the gun? And what was he doing? And there was no response. At which point in time, the defendant indicated they had to go, so they proceeded to drive in the direction of Atlanta from the Quick Trip, which was southbound. It was, I guess, Miss Carlin's understanding that they were going to stop somewhere in Atlanta, but they continued driving past Atlanta and ultimately just drove with no intended destination in sight. However, they got onto I-16 and took an exit to Jeffersonville, Georgia, within the jurisdiction of Twiggs County, and drove a few miles past the exit, past Old Marion Baptist Church, and drove to a wooded area where Ms. Carlin indicated that she and the defendant attempted to, and did in fact, conceal the body by putting it into a wooded area approximately 70 feet from the dirt road. They then drove back to the defendant's residence, picked up the defendant's uncle, and with some cleaning supplies, drove to her mother's residence at 1038 Sasha Lane when both of them proceeded to clean up the vehicle. There was a defect in the back of the front headrest, which is where the defendant placed his firearm and discharged it in the direction of the victim in this case. They purposefully moved the front passenger headrest and switched it with the front driver's seat headrest, and left the vehicle there, at which point in time, Ms. Carlin indicated that they then drove back in the direction of the body. And at some point in time, there was an argument between the defendant, the uncle, and Ms. Carlin, at which point in time, both the uncle and the defendant got out of the vehicle and Forsyth, Georgia. And
what vehicle are we in now? Not the CRV that got left.
No, I believe Ms. Carlin indicated it was her Lexus.
So her car, not
car.
The uncle's or Mr. Bonaventura.
No, sir.
Okay.
So it was a completely different car. She attempted to look for the defendant. However, she could not find him and then drove back in the direction of her residence. At some point in time, she attempted to make contact with a friend. She did in fact make contact with this friend who would also testify in this case. That friend's name is Jessica Alexander. And she essentially confessed to her the events that transpired that early morning. She indicated that she would tell the police, but Ms. Alexander found out that she never did. So the following day, she notified the Alpharetta emergency hotline that she had information about a potential homicide. At that point in time, investigators from the Alpharetta Police Department were already conducting a missing persons investigation based on the fact that the victim's mother had reported him missing, and because he was a juvenile, they initiated an investigation immediately. The victim's mother indicated that he was last seen with a shirt, shorts, and a distinctive gold medallion, which again will become relevant as I indicate the factual basis. She notifies police they're investigating, and through their investigation, they find out from Shane Holder, who was at the Econo Lodge staying there with the victim, not in the same room, but in the same building. They found out that one of the individuals that was last seen with the victim was Hallie Carlin, the defendant's girlfriend. So police attempted to contact her, and they continuously contacted her throughout the day, even while she was with her friend, Jessica Alexander, confessing to her. She ultimately did not go to the police. She had her mother go on her behalf. And when she did speak to the police, she provided false information as to the events that transpired. She's truthful up to a point where she indicates that the three of them went to a quick trip, but thereafter provided false information. However, the informant did in fact tell the police everything that Ms. Carlin had told her, to include details such as her driving her mother's vehicle, that they got off at Jeffersonville, Georgia, that they passed Old Marion Baptist Church, and that they.
And that stuck out because someone's familiar with Jeffersonville, Georgia, or just Ms. Carlin remembered the name of the church she drove by?
She remembered, according to Miss Alexander, and in fact remembered the road where they stopped and disposed of the body, Glover Road. And all that information was provided to the police, who then relayed that to the Twiggs County Sheriff's Office, who 24 hours after having received that information did find the victim's body severely decomposed at that point in time. While they were also searching that area, they found a mailer addressed to Sharon Carlin, which is Hallie Carlin's mother, that was at the location, and subsequently confronted Hallie Carlin with that information, at which point in time she broke down emotionally and indicated that the defendant was the individual who discharged the firearm, that she helped transport him to and from that location. She did subsequently, when being transported to the precinct, invoke her right. So much of the information that I'm providing to the court is what she would testify to in accordance with the proffer that she provided the state back in June of this year. Based on the investigation, they did execute a search warrant and arrest warrants on the defendant, who at the time was in the custody of the Monroe County Sheriff's Office, as well as subsequently transferred to Polk County, where he actually had warrants for an aggravated assault. When they looked at the defendant's property, they found a Walmart receipt dated for June 14th at approximately 2:23 p.m. This would be the same area where the defendant was last seen by Hallie Carlin when he got out of the vehicle. Based on that receipt, they attempted to locate surveillance video of the entries and exits of that Walmart in and around that time frame, and they observed the defendant wearing a gold medallion that looked distinctly similar to the gold medallion that the victim was last seen wearing, and thereafter subsequently executed a search warrant and arrest warrants on the defendant's property. The state was ready to try this case today, and we, based on the, I guess, conversations that took place at the 11th hour yesterday, the state believes that there was an adequate resolution in this case based on the amount of time. Not to take away from the seriousness of the events that transpired, but as the court knows, the state has the burden of proving its case beyond a reasonable doubt, which we believe that we could, but it's always possible that anything can happen. And I think that this offer adequately weighs the seriousness of the events that took place, as well as takes into account the defendant's willingness to accept responsibility to some degree, as well as to mitigate any potential risks at trial. With respect to 21 SC 179973, the defendant is charged with possession of a dangerous weapon and criminal damage to property in the second degree. On April 6th of this year, while the defendant was in the custody of the Fulton County Jail, the detention officers in this case noticed a odor coming in the direction of the cell that the defendant was in custody in, which point in time they observed and conducted a search of that cell and found a man-made knife, more commonly known as a shank, in plain view on the defendant's bunk, at which point the defendant claimed ownership of that weapon. And in addition to that search, they observed a tablet that was assigned to the defendant, an iPad that was damaged. And when confronted with that, the defendant simply said, "I was bored." And therefore, the defendant stands accused of the two charges and is accepting responsibility. So the state's total recommendation in this case is 40 years to serve. And I do have the signed indictments and accusations, as well as the plea of guilty form for the court.
All right, I'll go over those in a minute. Mr. Smith's family supporters, are there any who had a victim impact statement that they wanted to be shared through you or they're online?
No, Judge. We spoke at length with them yesterday, and in fact, the victim's mother was in fact a fact witness in this case, given that she was one of the last people to see him and was able to describe him. She was on board with this. She thought it was an adequate amount of time. Obviously, nothing will ever replace what happened, especially the 2 days that took place between the victim's homicide and subsequently being notified that he was in fact dead when she was holding out hope. I don't think anything's really ever going to change, but she understands the risks and benefits of going to trial, as well as the risks, the pros and cons of this plea, and is on board.
Tell me a little bit about, thank you. I didn't hear any factual basis for counts 5 and 6.
I apologize, Judge. Thank you for reminding
It's
me.
okay.
The defendant was in custody in Polk County Jail, at which point in time he made two.
And he was in Polk County Jail for something different. You mentioned an aggravated assault, not for the Elijah Smith situation.
No, sir.
Okay.
He was actually in custody there and was making phone calls to 2 separate individuals, not to Hallie Carlin, but in those jail calls, he was attempting to get a message out and wouldn't indicate what the message was, simply indicating that he needed to get a message across to her, wouldn't indicate what it was on the phone calls, when he was not to have any contact with the co-defendant, Hallie Carlin, which is what she was at the time, and I guess still is. So that is the factual basis for those phone calls. Those phone calls having taken place on the dates indicated on the indictment, August 23rd and August 21st.
Okay. And by that time, Mr. Bonaventura had a hold from Fulton County for the homicide investigation into Mr. Smith's death.
Yes, Judge. He was, arrest warrants were issued on or obtained on June 17th, and I believe they were executed on June 20th when they conducted a search of his property at the Polk County Jail.
Okay. By then, he was already in custody in Polk County for these other things.
Yes, sir.
Got it. Okay. Thank you. Officer Brown, thank you for joining us. Are you able to hear me?
Yes, Your Honor.
Does Mr. Bonaventura have any adult criminal history here in Georgia?
Yes, out of Polk County, for, let's see, I have the indictment for criminal attempt to commit a felony. It was a conditional discharge sentence, and it'll be open until 6/14/2022.
And conditional discharge is like first offender, but it's under the controlled
Drug
substances.
Yes.
Pardon? Okay.
It's 1613-2, Your Honor.
Okay. Great. Thank you.
You're welcome.
Mr. Franklin.
Thank you, Judge. And I'm moving from the seat that I was at just because my angle was awkward otherwise. You know, oftentimes when I find myself before Your Honor, I am usually articulating a different version of events from the state. A lot of the times we just don't agree with the way that things are put forth. I don't have a lot to say different than the account that Mr. Rao put forth. Mr. Bonaventura Flores wants to take responsibility. The hang up for a long time had been not even numbers, just kind of the characterization and the implication of being a quote unquote murderer. Had we proceeded the trial, our defense would have been one of kind of an imperfect, I believe, mistake of fact kind of situation, which Mr. Rao has spoke to. This contention that Mr. Bonaventura Flores thought that Mr. Smith was in fact attempting to rob them. The proffer given by Ms. Carlin had been very clear that there wasn't any dispute or argument or anything in the 10 or 15 minutes that Mr. Bonaventura Flores and Mr. Smith had known each other. That when she got back into the car, she handed some stuff back over to Mr. Smith, and I don't know if it was just the movement. Ms. Carlin made mention of the fact that despite it being her car and Darian being her boyfriend, that he sat in the back, and that per her understanding of things and knowing Darian, that he may have been a bit paranoid or suspicious, and that's why he in fact sat in the back seat, which is an odd fact necessarily, but I think it gives credence to what we're saying here, that Mr. Bonaventura Flores was on high alert, if you will, and simply misread a situation to tragic effect, and compounded that bad reaction with the circumstances that involved driving twigs and trying to cover up something wrong that had been done. This resolution solidifies essentially what we would have been asking for from a jury at trial. Just an understanding that this was not a malicious in heart, I'm mad at you, I want to get you kind of situation. And I think it's reflected in the fact that he was 19 years old at the time, he's 23 now, and he's pleading to a amount of time that is nearly twice the amount that he's lived in his life, which is not a small thing to do. I will say that when we first began to legitimately have conversations about the potential of a voluntary manslaughter resolution, the conversations with Mr. Flores were very quick and easy. He was like, yeah, like if we can do that. We had offers that could have potentially guaranteed him a shorter period of time in custody. But he was very adamant just about the charges that came with that. And given that it doesn't change where you would go to prison or where you were housed or anything like that, there are just certain things that after you've been in custody for 4 years, just have a certain level of value. Mm-hmm. And if the opportunity to be held accountable allows for it to be characterized in a way that feels more fitting, at least for our side, it was worth pursuing. I feel like it's a good resolution because I don't know if anyone is totally like excited. We're certainly grateful and for what we've been able to accomplish, but I think the best deals are kind of the ones where everybody walks away and kind of feels like maybe you left a little something on the table or maybe you didn't. And that is, I believe that's about it from our end.
Okay, thank you. And you did add, my one question was going to be any connection between Mr. Smith and Mr. Bonaventura, and it sounds like they were complete strangers until Mr. Bonaventura and Ms. Carlin made it to Mr. Holder's room to buy some marijuana, and Mr. Smith appears in their life. It wasn't a previous relationship, previous difficulties or friendship or anything. No. Unknown guy.
Nothing that I've had in my communication with Mr. Bonaventura Flores, nothing that any of the other witnesses, Mr. Holder, Ms. Carlin, said in the discovery. Mr. Smith just happened to be in Mr. Holder's room at that point in time. And they decided to go get some rolling paper so they could potentially smoke together. Mm-hmm. Just that kind of situation.
Got it. Okay. Mr. Bonaventura, there are a few things I need to cover with you before I can accept your plea. But I also want to make sure if there's anything you want to say that you have an opportunity to do that. You have a right to share with me anything, but you don't have to say anything at all. Mr. Franklin has helped me understand your situation. I don't think I'll ever fully understand it. It's a complicated and difficult one. But if there are things that you want to add, now is the time. And you're also welcome to say you're good.
Mr. Bonaventura Flores has nothing to add. I had explained to him before that I would walk through the circumstances of things. and
Sure.
You've heard him just kind of be soft-spoken and quiet and. doesn't
Got it.
believe
Okay. Mr. Franklin, I don't know that there has to be a waiver, although I think I saw one in the docket, but are you waiving on behalf of Mr. Bonaventura his right to have the two charges in 21 SC 179973 presented to a grand jury?
Yes, sir.
So we can proceed on an accusation.
Yes, sir.
I'm going to verify some signatures. Mr. Bonaventura, I see your signature on the indictment in the 18 SC case and the accusation in the 21 SC case. Did you sign both these documents?
Yes, sir.
All right. And Mr. Franklin, you've signed them both as well?
Yes, sir. And I will acknowledge that the waiver of rights form, the actual initials are my handwriting. I went to the jail.
I'll get to that.
Okay.
I'm handling these things first. I'm going to date the accusation. The signatures don't have a date. Any objection, Mr. Rao, if I date the signatures on the accusation to today, the 14th of December?
No, Judge.
Mr. Franklin?
No objection.
All right. Great. And Mr. Rao, you signed both the indictment and the accusation.
Yes, Judge.
All right, Mr. Bonaventura, this plea of guilty form lists a lot of what Mr. Rao asked you about today. Your right to have a lawyer, to have a jury trial, cross-examine witnesses, et cetera. Did you and Mr. Franklin spend time going over this form today, yesterday, some point recently?
Yes, sir.
Okay. And your initials, as entered by Mr. Franklin, are next to all the things indicating you understood them. Did you direct Mr. Franklin to put your initials next to the things you did understand?
Yes, sir.
Great. And eventually on page 4, there's a place for a signature that you signed today in Mr. Franklin's presence. Is that correct?
Yes, sir.
Then, Mr. Franklin, you executed the certification of counsel on the next page.
Yes, sir.
All right, great. Mr. Bonaventura, I find that there is a factual basis for both your pleas, which means if you had decided to go to trial, I find that a jury could, I don't know if it would, but it certainly could find you guilty of all the things you're pleading guilty to in the indictment, the 18 SC case, as well as the accusation, the 21 SC case. I understand why it's a plea to voluntary manslaughter, but I find that the state, had it gone forward, had sufficient evidence to prove murder, if that's what the jury decided the verdict should be. I also find that your plea is knowing and voluntary. Two different concepts. Voluntary means that you're entering these two pleas today because you've decided, after thinking hard and talking with your lawyers, that this is what you want to do with your cases. It's not someone forcing you to do it, but it's Mr. Bonaventura saying, this is how I want to move forward. Is that a correct statement?
Yes, sir.
And a knowing plea is simply one that is an understanding plea. You've understood all the things we've been talking about today when Mr. Franklin is explaining to you about defenses and voluntary manslaughter versus murder and co-defendant testimony, et cetera. Do you feel like you've understood those things?
Yes, sir.
You feel like everything we've discussed today, you've understood?
Yes, sir.
All right, then I will accept your plea in both cases. I will follow the negotiated resolution. You are accepting a very heavy burden by entering this guilty plea, but I think you have a very heavy burden to bear because of what happened. It may well have been a grave misunderstanding on your part, but it's the kind of thing that happens when someone young's got a gun and you pulled the trigger and the guy's dead, and you cannot undo that. Mr. Smith's family will forever carry that loss, and it's a loss that you caused, maybe because you misunderstood what was happening at the time, but that doesn't explain away what you did. But I think you understand that and you're acknowledging that by accepting this offer from the state and moving forward. And this isn't going to feel all that great right now, but it does provide you with some certainty. If you had gone to trial and if you were found guilty of murder, then your sentence would have to be life. It could not be less than that. And while life is a parole eligible sentence, it's only eligible, it's not guaranteed. Here, you know you'll get out. It's a long ways away, but there's that certainty. And there's a reason for you to try to lead your life while you are in custody as productively as possible, because there is that next day when you will walk out of prison. Unlike Mr. Smith, who doesn't have anything left. So I think in the end, that may motivate you a bit as you spend your time with the Department of Corrections. So on 18 SC 162212, count 1 has been reduced by the state to voluntary manslaughter. I'll sentence you to 20 years to serve. Count 2 is vacated by operation of law. 3 merges into 1. Count 4 is, I have to sentence you on counts 5 and 6 first. Counts 5 and 6 will both be 2.5 years. 5 is consecutive to 1. 6 is consecutive to 5. And then count 4 has to be 5 years and it has to be consecutive to everything else. So it will run consecutive to 6 and it will be 5 years to serve. That adds up to a total of 30 years to serve. You'll get credit for every day you've been in custody since you were being held on a warrant for this case. So it may be that the initial math is off a little bit, and you should talk with Mr. Franklin about that. The sheriff knows when you made it to Fulton County, and that's the easy math. From the day you made it to Fulton County through today, credit for all those days. But it sounds like there may have been a little bit of time when you were in Polk County. I say a little, it's still a lot. Every day counts. When you've been in Polk County, but there was this hold for these charges. And it is my intention that you get credit for those days as well. It's a small percentage given the overall sentence, but you ought to get credit for that. So if you're looking at the paperwork and you feel like that Polk time is missing, let Mr. Franklin know. And if I need to amend the sentence to ensure that you get credit for, I don't know if it's weeks or months, but whatever it is, again, it's your time, we'll fix that. In 21 SC 179973, again, I'm accepting your plea there for the reasons I said before. There's a factual basis, and I find that your plea is knowing and voluntary. Your sentences to count 1 is 5 years to serve. Count 2, 5 years to serve consecutive to count 1. And the sentence in 21 SC 179973 shall run consecutively to your sentence in 18 SC 162212. That adds up to a total of 40 years. As I said, credit for time served. We'll build that into the 18 SC case because that's the sentence that starts running first. And I believe that covers everything. Mr. Rao, anything else on behalf of the state or Mr. Smith in connection with Mr. Bonaventura's cases?
No, Judge.
Mr. Franklin, anything else on behalf of Mr. Bonaventura?
Nothing further, Your Honor.
Thank you for your work on this case, Mr. Bonaventura. I know you know that Mr. Franklin has worked hard on your behalf. It took a little something extra since he transferred to the courtroom next door. He has a whole nother set of cases, but he asked his supervisors to be able to hold on to a couple cases that were important to him, where he had made a connection with the defendant, and this was one that he asked to be able to keep. And his supervisor, even though that meant extra work for Mr. Franklin, he let him keep it. So you were very, very well represented in connection with all this. And that is it. Mr. Singleton, nice to meet you. Mr. Rao, if you would sit tight while they get Mr. Bonaventura situated. Thank you, Officer Brown.
Thank you. Have a wonderful holiday.
so we can go off the record now. Mr. Mitchell, thank you for being here. This is where you were supposed to be. But your lawyer probably should have told you how things were playing out. The prosecutor in your case had a death in the family. And so your lawyer agreed that the case could be continued. And apparently she did not get that message to you. You ought to reach out to Ms. Patel, but I'll let her know you showed up because this was the day we would have picked a jury in your case. Because this guy pled, you're up next. But the prosecutor had this real sad development very recently, and I think the services aren't till tomorrow. And so we moved your trial off to a future date. So reach out to Ms. Patel. Do you have a way to reach her?
I just got a phone, sir. Do you know when my next court date is?
I'm not sure if we added you directly to the next calendar or the one after that. But if you want to sit tight, Mr. Franklin is a colleague of Ms. All right, you know how to reach her? Okay, thank you for being here. I'll let her know you were here. Take care. What's happening with Ms. Carlin? She's still on the trial calendar. Obviously, we're not going forward today.
I think the intention is to resolve.
Okay, that's always the intention, but do we need to put it on the trial calendar? Should we expect that in the very, very near future? Does she have Mr. Rousey?
Yes, Thomas Rousey.
That you and Mr. Rousey will be reaching out to Ms. Nelson to get that?
Yes, that case will.
Okay,
It's not the intention to.
right, but I just need to make sure that that happens. And so we need to keep the pressure on. What makes the most sense for that? Should we set it down for a plea or just add it to the next trial calendar? It sort of gets lost in the shuffle in the trial calendar because we'll be focused on folks who've been in custody for a long time, and she does not fall into that category. And then it's going to be 2023.
It was my intention to get in touch with her counsel as I've been in touch with them. Have her ready to present her testimony this tomorrow.
Mhm.
So I will reach out to them. I will let them know of this and we'll have our necessary discussions. And I will notify Ms. Nelson that we need it. That's okay.
That's great. I'll just have her bug you, and we may even peg a date, and it will be in the new year. It won't be between, unless Mr. Rousey is real anxious to make it happen this year. We suddenly have lots of time this week. So if everyone agrees they don't need the full notice of a published calendar, we can make it happen. So I'll probably have Ms. Nelson just check with you so that you're focused on this case right now. You'll be distracted very soon by other cases where judges are hemming and hollering. We just need to take care of Ms. Carlin. All right. Thank you, everyone. Happy holidays if I don't see you all before you go away. You did not keep that tie on very long. Oh my gosh. The little ones in school?
Yeah.
Good.
Multiple.
And I mean, like school is open and they are able to go.
Yes.
Good.
Kindergarten and first grade.
Excellent. Same school?
Yes.
Where?
Harmony, Clay, Leland Elementary, Cobb County. So maybe 5 minutes once you get into Cobb, coming for Fulton. So
Yeah.
right there.
Excellent.
Cool. Well, absent, possibly said second chair on some of the stuff that I passed on. That concludes my business with your court.
That's it. My
sir.
gosh. All right. I'm sure you'll be consulted on a couple of those
Yeah.
cases, but good luck with Judge Leffridge. Her docket has gone like this. I don't know if that was partly before you got there or.
We helped make sure they didn't grow any larger.
Yeah.
I'm not sure if you're familiar with April Northcross.
Mhm.
So she was in there before me, and I think under her leadership from the defense perspective that
Churn
a
through.
lot
all
of stuff
this.
was able to get done because
Thank you for your help.
I may be the sixth attorney on that load, like that half of the numbers
Yeah.
in the past 2.5, 3 years. So
Wow.
it's like some of the guys I represent, I'm their fifth or sixth attorney. So
Good.
it's
Nothing like continuity.
right. But thank you, sir.
All right. Take care. Hold on one quick second. Dip. So you guys keep talking. I gotta go down and release the jurors in a little bit. But I gotta, Ms. Nelson's got a couple questions, then we'll go down to 1D. Okay. Yeah, I've just put guilty all the way down, and because like if it had been a trial, they would have found him guilty of felony murder and it's vacant.
Okay, and so then you said, just so that I understand, number 5 is consecutive to number 4. Number 6.
No, 5 is consecutive to 1. 4 has to go last, just because usually they put it as the last count for this one. So it goes 1, 5, 6, 4, the order. Right?
No, just say you can take him down.
And did I gave you all the, I did not. Here are the signed documents. Bonaventura, strange guy. Let's end